In the US, pharma class actions are not commonly certified. This is because the individual issues of causation undermine the commonality, predominance, and superiority elements of the US test.
Right, so this means that large-scale pharma litigation in the US tends to happen through multi-district litigation, which means managing thousands of individual cases.
But by contrast, in Canada, there is no predominance requirement for certification, so pharma class actions are more common. The exception to this is in Ontario, which recently introduced a predominance element to its test. The case law around this requirement is still developing, but we might see it have teeth in the pharmaceutical context.
I'll also add that when a class action is launched in Canada, usually you can rely on what occurred previously in related American proceedings. But this isn't the case for pharma because of these procedural differences, so you have to approach things with a different lens.
That's right, Myrna. For us, it's all about certification. If you can defeat certification in a pharma case, there usually aren't many individual claims that follow, because Canada doesn't have an American-style system for managing multi-district litigation.
Canadian governments have increasingly been enacting specialized healthcare cost recovery legislation. This began with legislation with specific targets, tobacco and opioids. In these kinds of cases, governments are claiming costs incurred by governments as distinct from any individual's own cause of action.
This kind of legislation will be familiar to American lawyers since the Canadian legislation was modeled on US frameworks. Litigating against the government in this context raises special challenges. For one thing, governments can cause legislative amendments to take effect retroactively, which can have significant impacts on active litigation.
So one instance of this is the opioids litigation in British Columbia. In that case, the government started its litigation, and then the legislature enacted special retroactive legislation to govern the proceeding. One of the new retroactive rules was a provision letting the British Columbia government pursue a class action on behalf of multiple Canadian governments.
This kind of multi-government class action legislation was brand new in Canada, and it recently survived a constitutional challenge before the Supreme Court of Canada. It's a good example of governments using legislative powers to retroactively change the rules of the game in a way that ordinary litigants can't.
So, we've seen Canadian governments use this kind of legislation in specific contexts against specific products or industries. But there's been a controversial shift towards generalized legislation that would create really broad and uncertain rights of government recovery. This started in British Columbia with a bill called the Public Health Accountability and Cost Recovery Act, which proposes to give the British Columbia government the ability to seek relief arising from health-related wrongs.
This proposed legislation was placed on hold and has not yet been enacted as law. However, this highlights how class actions by governments raise both unique challenges, but also unique opportunities for advocacy. Prospective defendants can think outside the box in working toward different kinds of resolutions in this context.
That's right, Zoe. So affected companies can, working with their counsel of course, consider engaging lobbyists or lawyers specializing in government relations, and even capitalize on changing political tides. The litigation toolbox becomes much more creative here.
And this is especially relevant for pharma companies to stay on top of. Watching the trends, we wouldn't be surprised to see either more product or industry-specific legislation targeting pharma, or more attempts at generalized legislation that capture defendants in that industry.
We are seeing increasing efforts by the plaintiff bar to broaden what a class action can legally capture. It's important in this context for defense counsel to focus on the parameters established by the case law.
Absolutely, Myrna. For example, we have defeated certification by relying on the law surrounding compensable harm. We saw this recently in a proposed class action we defended following the recall of Valsart, a blood pressure drug, which was alleged to be contaminated with probable carcinogens. In that case, the class sought damages for fear and anxiety that they claimed were caused by the recall.
That was an Ontario case, and the Court of Appeal found that under the existing law, that kind of harm was not compensable in this context. We've also seen similar judicial reasoning from British Columbia on this point. So the trend from the plaintiff bar is to find ways to plead broader kinds of alleged harm, and defense counsel have to show why our legal system is right to put fences around those efforts.